for the service businesses Industry 4, or the fourth industrial revolution. So today we have smart factories with autonomous robots, machines that can speak to each other. We have AI, we have 3D simulations using real-time data to mirror the physical world into the virtual. We have 3D printing used to prototype different products. Our factories today are getting smarter, more efficient, less wasteful. And this is not limited to only the product and manufacturing sector. We're seeing these changes in the service industry as well. I know there are not many of you here, but could we have a show of hands? How many of you have seen a digitized menu in a restaurant? A screen? Thank you. How many of you, and I presume this is all of us, use web check-in or get your boarding pass at a kiosk in an airport, right? How many of you have stayed at an Airbnb? So exactly, so thank you. So today, the service industry is being tasked with the obligation to innovate disruptive digital business models in order to be competitive. The service industry is required to digitize business processes across the entire organization. We have new methods and processes of data collection. We are generating data to determine how to refine our products and services. And just like the screen asking you to rate a customer experience at a checkout counter in a department store. So in such a world, how do you identify the IP? And more importantly, how do you identify the IP that is worth protecting? Do our existing laws provide adequate protection for this? So we're going to start our discussion today to briefly discuss the fourth industrial revolution, or Industry 4. Mr. Anubhav Kapoor.
Thank you, Lynn. It's always hard to start a session after lunch, so good afternoon, everyone. But talking about Industry 4.0, I would just take you back a bit in terms of what were the different industrial revolutions and how the patent law or the IP laws in the country helped them grow, right? It's the other way around, because how I see it is that the IP laws actually contributed significantly in putting each industrial phases in place and in the way we know them, right? And the big question before us are the current laws, which were basically made for an analog world, are suitable for a digital world now, when we are talking about digital, a connected world, smart cities and smart homes and things like that. So just taking you back into a little bit of history, let's begin with Industry 1.0. And Industry 1.0 was more to do with mechanical machines, the steam engines, and that is the point when the patent laws emerged, and we still have patents which kind of are on looms and weaving machines and things like that, right? And that is where the whole concept germinated that yes, we should give protection to people who are spending energy and in innovation and giving them some exclusivity in the law. And then this whole move went into an industrialization phase, which we called Industry 2.0, which was more symbolic of assembly line productions. The electricity was there. People tried putting electricity into almost everything, making machines more bigger, and production and the volume was what was the emphasis at that point of time. And I think that is also a point when the maximum, if you see the innovation graph or the number of patent filing graph, that is also a phase when this whole curve seems to have taken a jump up. And that is also where the laws seem to have become more and more acclimatized to that kind of a industrial setup or economic environment that was there in that phase. And then came Industry 3.0, which was more of computers, electronics, automation. We tried to automate every process. We tried to make many of the things which were into ledgers and books and manual into processes which could be automated, and information sharing was the prime focus there, right? And that is where Industry 3.0 came and gave us rules which were more into how do we see innovativeness and inventiveness into computer applications, right? How do we see computer related applications or inventions, and how do we evaluate them? And that was also a point when the physical laws, IP laws which were applicable more on a physical world started moving towards little more of intangibility world, or where it was more of softwares, right? But at the same time, the courts, how it evolved was two factors. One was there was a concept that was derived, which was called as the technical effect, right? Still the mindset under those laws, and these are the laws which are still in vogue now, courts use them to evaluate, and the Indian legal system evolved basically on the lines of the European system, Section 52 of the European patent regime, and then the Indian regime that is there, the 3Ks and the 3Ds that we discuss always, right? And this is where the computer-related applications became more important, because that is where we started deriving about how do a technical invention which does not have a physical attribute to it, but adds to that technical invention or has a technical effect, and that was considered to be patentable also. And some of the examples of course, the technical effect definition that the courts have kind of over a period of time emerged is if your software kind of gives you better speed, or you have a better way of searching the net or network, and things like that, right? And it evolved as we know the law today in terms of computer-related applications. But something else also what happened, what we now call as Industry 4.0. And this is basically where we talk about terms like cyber-physical systems, or CPS, or IoT, Industrial Internet of Things, or IIoT, which is Industrial Internet of Things, right? Which is basically the industrial or the manufacturing application of the IoT world that we have. And the backbone of all that, what was happening was cloud computing, right? The AI, what we call as neutral networks, right? And that is where the whole technology piece was evolving, where there is a stretch now between, and it is getting more and more away from the physical world now, right? And that is where the stretch on the laws are happening right now, and that is what the subject of debate today is. And there, basically in Industry 4.0, there are three kinds of, you can bucket all the technologies into three buckets largely. The first is basically all the innovations that are happening in what we call as interconnectivity, right? These are applications which kind of get into or the core technologies which are more of hardwares like sensors, right? Or things like secured databases, or adaptive databases, which are intelligent databases, or security systems which allow us to implement these digital technologies into the real world. The second bucket probably is the enabling technologies, right? Which we basically call as 3D printing, AI, artificial intelligence, machine learning, things so and so forth, right? And the last bucket is the applications, the domains, right? Which uses the first and the second, and then makes applications for the last piece of things, like, which basically, this is the common terms that you hear: smart homes, smart factories, wearables, smart wearables, and this is the application domain. So as far as Industry 4.0 is concerned, I think the innovation diagram as I draw it, the maximum innovations are happening in what we call as application domains right now, and that is what creates a lot of buzz because it touches our lives directly, right? This is what we use every day, right? So that is what we are feeling the change. But the real drivers behind it are the core technologies and the application softwares or the enabling technologies which are really the subject matter of what is under the patent domain. And what is causing the stretch is that the traditional concepts of IP laws or patents that we applied in determining the threshold where an innovation could be given the status of a patent have now become more fuzzy. And why I say fuzzy is many of these inventions which traditionally used to be giving an effect on a physical world, now the effect is not visible in the physical world. It's all virtual, right? You may have a database or a machine learning algorithm which kind of creates intelligent machine, but it is not visible to you in the physical world. And that is where the tests of patentability that were conceived under the traditional laws or the current laws are getting stretched. I think with that note, I will pause here and let other speakers speak, and I'll come back to this point again.
Thank you, Anubhav. So, Mr. Damodar Vaidya wants to speak about the nexus between service businesses and Industry 4.
Yeah. Thank you, Lynn. I think the audience here is mostly IP professionals. There are entrepreneurs or company people, like we have 2 people on our panel. Some people may be in the audience. And the subject is essentially the IP, service business or businesses, and Industry 4. Anubhav has explained, Lynn also explained what is Industry 4. I think by and large we all know. It is driven by sensors, it is driven by actuators, it is driven by cloud computing, it is driven by man-to-man connectivity or person-to-person connectivity, person-to-device connectivity, and device-to-device connectivity, which is not so far ubiquitous, but is likely to be ubiquitous. Then we have the bandwidth. Today, we are able to watch video on our mobile phones. It was not so few years back, so abundance of bandwidth. So connectivity is very good. The AI technologies, the management frameworks, all in place. All Industry 1, 2, 3, 4 have given us all these things. The question is that how IP professionals, entrepreneurs, consumers are going to be impacted, or they are going to utilize this revolution. The first and foremost question is that coming to the services, what are the services? Essentially we understand services means which are anything which is personalized. There are pure services, there are product services. For example, pure services, banking service, transport service. It doesn't involve exchange of the product. It involves experiencing. So there is a typical word that service is experienced. Now we go to the products. The products are not simply a product, but the product as a service. And we go to restaurant. Essentially what we eat is a product. But this eating we only enjoy if there is an experience associated with it. So it is personalized. So although there is a product, when you make it personalized to your taste, and when you experience certain things which you cannot explain, that is the characteristics of the service. How does this Industry 4 is going to make a change? Anubhav has explained that Industry 1 to Industry 4, what has been the journey. So before Industry 1, there were pure services and there were products which were as service. But Industry 1 and Industry 2, with the mass production, productivity improvements, the services were converted to the products. We were only given the choice that this is the black cars available, that is Henry Ford's Industry 2 model. You have only to choose what I make. You have no choice. Industry 4 is going to change that scenario. I think the products you are going to make to your choice. And that is what will be the effect of Industry 4. I am not giving explanation of what is Industry 4 because by and large, every one of us has understood what is Industry 4. But what Industry 4 will do to us is that it will empower us to take the product which is personalized to us. The question is, how do we do this? How does the entrepreneurs will do this? Entrepreneurs will do this. This is the thought 2, either by creating new demands or manipulating demands. Now, this is a very dangerous word. What is manipulation of demands? And this is what is happening today. You are able to manipulate the demand because I read a story that if you read a book on Kindle, the Kindle finds it out from you because it has a camera. Now, on what page, on what paragraph you smiled or you laughed or you stopped reading there. So, when you read complete book, the Kindle knows that what is your profile. What kind of book should be read by you. This is one kind of manipulation. This is happening today. The second kind of manipulation that is more dangerous, and that is basically info technology and biotechnology combination. That manipulation is something that will dictate what you should do and what should be your choices. So essentially, what is important to be a human being, the ability to make choices. This ability to make choices will be dictated by reasoning, rational, and that reasoning and rational will be decided by AI. They will dictate it. What they will not be able to dictate on you is something what is called as intuitive thinking, your motivation, which is little beyond choices which are made on reasoning. For example, do we make all the choices on reasoning? If I am an economics student and if I am asked to buy a house, throughout my life I will never buy a house because in India, the opportunity cost of what I invest in house will always be lesser when I look at the interest options that is available. But we do buy house, and that is what is intuitive making choice. Those intuitive choices is something that will remain in our hand, and we will never be able to succumb to that. How do we use this intuitive thinking for entrepreneurship, organizations, to differentiate entrepreneurs from different entrepreneurs will be the subject that I will talk subsequently. But I will leave this thought here, saying that how Industry 4 will pan out, what will be the scope for doing the business differently, how this scope or these opportunities will be tapped by entrepreneurs, how the consumers will react to this, and how the entrepreneurs will organize the business to cater to these needs. The third part we will also discuss about the impact and what the IP professional should look for in this particular scenario and how they should help entrepreneurs to make use of this Industry 4 to do their business better. Thank you.
Thank you. So core IP assets need not be your patent. It could also be your brand. So I had this discussion with the CEO of a large service company. I'm not going to mention names. And I asked him what does he believe his core IP asset is, apart from his brand. And he said the experience that he provides his customers, the level of care, he believes there's IP in that. So let's discuss, in a service industry, what do you believe are core IP assets and what are their value propositions?
Well, I can start by giving a few thoughts. So if, and Mr. Vaidya said this, that there is, when you're talking about services, you're talking about a product that is underlying the services, and the services get sort of customized. And then we talk about Industry 4.0. So in my mind, when I'm looking at sort of the service industry, and I'm looking at what is it that we need to address from an IP perspective, the underlying basis, and sort of keying off of what Anubhav had mentioned, is data and computation. And I, by practice, am a patent attorney. So when I hear data and I hear computation, these are the two red flags that go up and say that data is not protected under patent law, computation is not protected under patent law. So now we have to start thinking creatively. And that's what I bring in as a private practitioner, on how to think creatively to address this issue of how would you use an environment that's going to utilize data and computation and come up with either products or services that can be protected. I think, and during the course we'll probably talk about how, from a government perspective, what the government should be doing, and what we are experiencing with respect to the judiciary, and how sort of all of us can get together and come up with sort of a roadmap or a framework or a proposed framework to help in this process.
If I may chip in on that. See, when we talk about what do we understand as IP in the service industry, the first thing that seems to come to mind to everyone is trademarks, right? Because that's the most robust in the service industry. Interestingly, since you mentioned we are in the post-lunch session, let me just share some stories here and not just give general gyan, right? In one of the instances in the darknet, the reason why a person who was dealing in drugs got caught was because he actually filed for a trademark for his site, So that's the extent to which people clearly understand the importance of trademarks when they're speaking about service industry. And there is no splitting hairs about whether people believe that it should be protected and completely and all that. And the courts also chip in reasonably well when we are talking about trademarks and the service industry. But let's move the narrative a little bit to patents, which has been discussed by all the other speakers so far. We are in the world of innovation, and we are, everybody wants to jump into, take a piece of that pie. Strangely, some of the persons who would be the strongest proponents of proprietary software, those who would fight tooth and nail to protect their rights, are the ones who also oppose grant of patents, on the ground that patents stifle innovation. I'm referring specifically here to this one case of Lotus Group LLC, which claimed to have the patent for, something that we all hate, for all you gamers out there, those in-app advertisements. Right? They are the ones who claim to have the patent for the in-house advertisements. And when this was being used by others and they sued everyone, including Kaspersky, most of the others seem to have settled, but Kaspersky stood its ground and it decided to contest this. At some point of time in the narrative, Lotus settles with them. So what Kaspersky does is it continues the litigation because it wants it decided and says, I want to go forward as a with prejudice contest. And then Lotus backs off. In this and in subsequent litigations on this, you will find that all the Apples and Microsofts also chipping in when we are talking about software patents. One of the trends, and I know that it's out there, so let's address it right away, right? one of the trends seems to be that where the patent protection litigation is initiated by an aggregator of patents, or what the industry calls as software patent trolls, there seems to be a collective opposition to that. Whereas where it is an individual who would file, when I say individual, I mean an individual entity, which would file for protecting its own patents, then the sympathy seemed to lie with the innovator, and the industry is happy to allow him to prosper. So just to give one example based on what was a very, very interesting issue that was raised in the earlier session. Normally I don't read out of slides, but this is something I definitely cannot memorize. So I'm just going to read this part out from the patent claim. This is what the patent claim says. An extrusion head for depositing layers of solely solidifying material in a desired pattern to form three-dimensional physical objects. Any idea on what they're talking about? I've given you a hint also of that. Absolutely, so 3D printing. So one of the cases that came up was of microboards technology, which opposed the patent grant to Stratasys for 3D printing, and in that case, Stratasys succeeded in upholding its printing technology. So what I was trying to draw a distinction here was in terms of the aggregator patent troll litigations as opposed to the manufacturer, or the innovator's patent protection mechanism. Just to close out on the issues that you were mentioning about, how do you identify your IP assets? It's a vast world out there. We are all talking about technology today, and all the technologies we are speaking about today may become, outdated in no time. And law is still catching up. Law will always have to do a catching up game because it can never be ahead of the curve. But law is to be formulated in such a way that it is dynamic enough to keep pace with evolving technologies. It cannot be changed as and when new technologies come. If we could have a dynamic contract act which worked when they did not even know what telegraphs or telephones were, and it can apply equally today in our world of technology and innovation, that is dynamism for you. So the reason I'm bringing that up is that I feel that there has been substantial focus on IP when it comes to supporting the manufacturing industry. But the manufacturing industry is kind of like the tip of the iceberg, with the base of the iceberg being just below the surface. And that base of the pyramid is the service industry, which supports the manufacturing industry. We all buy a car once in our lifetime, maybe twice, but what do we do day in and day out, year after year, maybe once in 3 months, once in 6 months, we service it, right? So it's the service industry which piggybacks on manufacturing or may have a standalone life of itself that dictates how, that dictates the real, sustainability of the industry, I would put it as. So what we need today is recognition of the IP assets and the IP rights when we come to the service industry. Understand that it goes beyond just trademarks. Understand what it means when we talk about copyrights and in the service industry, and have effective enforcement mechanisms which will help grow this field better. And finally, on that note, the national IP policy of 2016, I feel is already outdated because again, the policy documents can keep changing and evolving with growth and evolution in technology. So it focuses and talks about how service should be, a service industry perspective is what the IP enforcers, IP enablers like the patent office or the trademark office, etc. should follow. what it needs to look at going forward is how can a policy document, how can government help build this service industry further through IP as an enabler.
Thank you. Ravi?
Yeah, just to add on, and hopefully I'm audible at the back. Good afternoon, everyone, the learned audience. Had I been here at the conference last year, I would have, introduced my organization as a pure play financial services organization, as Mr. Vaidya, defined what's a pure play service organization. But in today's age, if I quote my CEO, we are a tech-driven financial services provider, which is a Fortune 200 organization, a laggard in terms of adoption, and a brand-conscious organization. So two things get covered from an IP perspective here. When it's technology, it's a lot of patenting. When it's being brand-conscious, it's a lot of trademark protection. And that is where our journey is moving towards. So a lot of IP 1, 2, 3, 4 got mentioned in terms of industry revolutions, but we are somewhere in between. We are probably at a IP 3, industry 3.5 version, attempting or aspirationally trying to move towards the 4.0 revolution, right? And I just want to ask, when I joined my organization 12 years back, there were 10 to 12 applications getting filed. I saw my first application, and it was about printing addresses on an envelope, right? 12 years, and the patent still did not get a grant, right? That has been the quality of the patent then, to today, where we only talk about cloud computing, blockchain, robotics and process automations, right? These are the things as an organization, as an in-house IP council, that gets me excited. From 10 applications then, we ended the year 2019 on healthy 76 applications. We rejected close to 120 invention disclosure statements, and of the total, only allowed 76 to see the light in the form of a patent, right? In the first session, Archana Shankar mentioned that there's close to 134 applications that got rejected, being computer or business method applications, right? And kind of 3K kills it for organizations like ours, right? And that's why, as an in-house IP council, we kind of now focus on a lot that is tech-driven. Now, who is going to get us these applications, inventions? It's not the IP service providers, or it's not an IP council like me, right? It's the inventors. And if the inventors are not educated what is IP, then how will we, managing our portfolios, look at adding quality, right? And these are practical challenges that I'm sharing with the learned audience here. Some of the focus areas for us have been educating inventors of POSITA, meeting probable inventors in smaller groups to make them understand what IP is all about, what can be copyrighted, what can be patented, what is a trademark. If I give you an example, we had secured patent protection for managing retirement for individual clients, right? We got that. We saw that it makes a lot of business sense to focus our energies on this particular product, launch it in the market. Can we launch it without a brand? No. We spent probably not more than 1/10 of our total budget on getting patent protection in various geographies. But we spent a lot of money towards brand protection. So if you look at the cycle for any organization, probably it starts with an idea, but it ends at selling that service to the end client, right? And for that, you need a very, very sound brand protection policy, and nothing is better than securing trademark for these kind of services. Today, that trademark exists in the shape of confident retirement for an organization like ours. I'll also share a story. I come from an organization where an inventor may be in his or her early 20s, brimming with confidence, full of ideas, submits an invention disclosure stating, probably I've achieved the end of the world, or, on cloud nine, submitting a patent application without knowing probably the possibility of a grant in view of case laws like Alice and Bilski, maybe less than 1% for that matter. Same inventors got married, hairline receded, right? But their patent application was still pending and continues to be pending. So as an organization, we decided to work towards quality. If I talk about the future to-dos that we have set for our department is focus on a lot of continuation applications. Look at, broadening the scope of what we presently have, where the notice of allowances have been received. Be future ready for case laws like Bilski, Alice, which at the end of the day for organizations like us, where we've spent millions of dollars into getting patent protection, but tomorrow we get to know that, okay, there is a case law, we need to do an IP audit. Looks like we may be on the verge of doing away with 50% of our patent portfolio because we are at the risk of getting invalidated, right? Do an FTO, sit with the people who are actually into product development and help them understand the importance of things like FTO, even if it is not about IP protection, right? As an organization, if you're based out of US, Europe, very mature markets, there are patent trolls which are just waiting for an opportunity for organizations like us, heavy on cash, but not very educated on IP, to do such mistakes and then get into expensive litigation claims, right? And those are the to-dos that I have. Just to sum up, how do we drive IP or innovation within organizations? We have a reward system, a recognition system. We have town halls in our organization where thousands of employees are there. We ask an inventor to storyboard their experience of going about an idea, giving them that visibility, rewarding them with, say, for example, for every application that we file, an individual inventor gets $5,000 as a reward from an organization like ours. In some cases, we also have royalty agreements in place. And all these are there just to promote IP, just to promote protection. And we have inventors at times also sit through examiner interviews in the US just to help them understand how life becomes difficult when they think they probably have it covered all and it's a brilliant idea, but that's not how an examiner at any of the patent offices may be thinking about it. So Lynn, those are few experiences that I've shared, some painful areas for us still, and there are so many IP service providers. If anybody has a solution, my average time required for an application to get a grant is 8 years. I always tell anybody who comes and meets us, if you can get that average down, I would be happy to have business with you.
Sorry, Ravi, I just wanted to interject to say your session sounded like that Tariq pe Tariq dialogue. And I just wanted to add that it's no different when we are talking about IP litigations also, right? So today, what are we really looking at when we talk about IP litigations? We are only talking about the ad interim or interim reliefs. Once you have received your interim relief, then the case literally becomes irrelevant thereafter. And in any event, by the time the case is taken up otherwise for hearing and a decision, the technology itself may become irrelevant. So, yeah, I just wanted to interject on that point.
Sure. But I just wanted to add to that in terms of, I just picked that keyword experience, right? And I think when we talk about brands, it is about experience, right? When I walk into a McDonald's or a Subway, it is that same experience that I am expecting again and again, and that is what creates brands. Now, let me just take it a little back and see how the modern IP jargons that we are using, or the smart manufacturing jargons that we are using, say IoT or industrial IoT, is helping create brands better. Right, and I was working in Domino's many years ago, and one of the challenges that we had was we used to ferry cheese, right? The mozzarella cheese that you love so much on your pizza, right? It is best when it is fresh, right? And it melts in the oven, right? And you get that fresh piece in front of you, right? And the challenge was the cheese left from one place to the other, and we were not sure whether the cheese received on the other end of the route would be fresh, right? And you know the problem? The problem was we did not have any way of monitoring what was between those 2 points that the truck driver was doing, right? Because the guy would stop, right? And he would switch off the AC because it saved him cost, right? And then when the cheese reached the other point, it would not be as fresh. And that caused a brand problem for us, right? Because Domino's means fresh pizza, right? You got to have the best cheese on your pizza, right? And that is what I think the industrial IoT has solved now, right? The coal fleets now have smart sensors. It has what we call as the IoT solution or the telematics or the smart telemetry, right? The fleets now are fitted with sensors which give you real-time data in terms of what the temperatures are, right? And if there is a disruption, you will get to know right there, real-time, what is the problem, and you can take those corrective steps so that you can ensure that the pizza, the cheese that is reached to you on the next point is as fresh as it started, right? And I think that's the experience that technology and the digital world is bringing and changing our lives now. And I have several other examples, but this is one of the early ones that touches me because I love pizzas, right? So.
Who doesn't?
Okay, so Anubhav has got all of us pizza hungry now, but sort of going back to a point that Ravi made, and I just wanted to add to it, and it's sort of instigating a different challenge or a different thought, is we end up looking, and this is what I see in India, it happens whether it's from a policy perspective or the patent office perspective or the practitioner's perspective, we look at Indian IP with the glasses of the US or Europe. You know, we're talking about what's happening in the US and how that should be implemented in India, and we talk about what's happening in Europe. And I think that is, at some level, that is what inhibits us from reaching our potential. I think India needs to decide where it wants to be 10 years from now. It does not have to follow the US. It does not have to follow Bilski. It doesn't have to follow Alice. It doesn't have to follow any of those processes. What India needs to do, specific to the service industry or specific to Industry 4.0, AI, whatever you want to call it, is identify if this is an area of growth for the country. If this is something that we are going to contribute to growing our economy, growing our GDP, and if it is important, then we should look and see whether we have the laws and we have the infrastructure to make this a better place for those kinds of inventions. If you think about it, we are not sitting, I mean, US has Alice and etc., but no one here is crying about the fact that it's tougher to get patents in the US. We still will file in the US, we still want to do it. Why don't we consider India as a jurisdiction that, yes, we have these laws, are they right for us? And if they are not right for us, do we have the courage to change it? Independent of what the rest of the world is doing. And I think that is a conversation we don't have enough, because we always end up being in the back foot. India is always, at least in the forums that I am in the clients that I meet, the international clients that we service, I'm always defending Indian IP regime. And I think that we have to move forward and say that I'm not going to defend Indian IP regime because the IP regime is being proactive. The Patent Office has done tremendous amount of work to sort of alleviate some of the concerns that Ravi was talking about, from a 9-year cycle to bring it down to a 4-year cycle or a 4.5-year cycle. I see Mr. Hemant Singh here in the audience, and you know, AIPPI has been instrumental in sort of having the courts now talk about how the IPAB should become more functional and continue the kind of work that we want to do. So there is a lot of learning, but I think that we're intelligent enough as a country and as a community to look at it and make that decision. Keying off of what also Justice Pratibha Singh said, that you know, the policy 2.0 is imminent, and all those things are there. So I would look forward to those aspects, to be a part of India that's recognized for being proactive rather than reactive.
So Mr. Soni, are you suggesting relaxing provisions of Section 3K? Because as a patent filer, I would be delighted.
I don't, it's not about relaxing 3K. It's about the correct and consistent interpretation of 3K. The equivalent of 3K is there in many jurisdictions. It's just that the patent office or certain examiners, because I can't even blame the patent office. There's a lot of progressive things that's happening there. It's a certain, the interpretation by a certain group, and whether that interpretation is consistent with where we want to go as a country. And I think that you're right, that consistency is not there. And that's the consistency that we have to try to achieve, rather than put a blanket statement saying 3K is bad, we need to get rid of it.
I just would like to add, what Ravi said is that pure service platform, they changed to technology plus services. Now, when he says technology, it means that there is some platform on which the services are built. And these platforms are technology platforms. For example, we used to do the business with bank, and that is something which is daily that we interact, and I can share my experience with you. That I had been banking with HDFC, and there has been innovation on the platform that they had net banking platform. And I see continuous improvements to the extent that I feel that probably in the last 3 years, I have never visited HDFC Bank. So what I do with the bank is now with the net banking, and at the most with their help desk. All these two services are something which is their differentiator, and I'm using the word differentiator, I'm using the word experience. Now let us turn to the IP. What is IP? IP is not patent, IP is not trademark, IP is not trade secret services. I mean that they are all IP, but not in isolation. It is the combination of this is really an IP. An IP for IP professional, maybe that these are different, but me as an organization, it is sum total of it, what goodwill I create, and what is my book value of the shares, and how much the people are ready to buy my shares for. Ultimately, what goodwill I create is what is the effect of that IP. Whether I get it through patent, whether I get it through the trademark has no value. What is valuable is brand. And the brand is created not by taking some registration. Brand is created by giving consistent experience and differentiated experience to the people. Let us go to the another experience that I had with the bank. For some reason, I had to open an account with the PSU bank because I could transact using only the PSU bank transactions. And when I opened the account with SBI, I have no hesitation in making that announcement. I find that my experience is pathetic. The comparison with the net banking that I get it with HDFC, with what I get with SBI, is no comparison there. So if you ask me, I will ever prefer HDFC to be my platform there. Now, when I create that brand value, how do I create that brand value? Not getting by patents, but innovating continuously, doing things differently, trying to differentiate with the competitors, and in doing so, if I believe that I have made a patent, I would suggest that file a patent. Yes, in 10% of the cases, you may not get the patent, but still you say that I have filed, and that I am practicing it. What is more important is that not getting a patent, but innovating it, feeling and believing that it is patent worthy, whether the patent office gives it or not, do you believe that it is patent worthy? That is more important. And if it is patent worthy, I am sure that it will make a differentiation. If it makes a differentiation, it will give good experience to the people. Your brand value will go up, and ultimately the purpose is served. Ultimately the purpose is more important than the means. And that is what I think IP professionals, the entrepreneur should look at it rather than looking at it in isolation. Thank you.
Mr. Vaidya, you correctly summed it up in terms of, see, section 3K is not a static section. Yes, it says what cannot be patented in a software regime, but our courts have been quite progressive. They have been giving very progressive orders. I think someone in the morning, I think it was Dr. Anand who touched upon the recent Delhi High Court judgment that was given on Fareed Alani versus Union of India, where there was a new interpretation, a very progressive interpretation given by the single bench of Justice Pratibha Singh in terms of how do you interpret this phrase, the program per se. And the per se word was kind of given much more explanation in terms of that it is not meant to be read in a way which scuttles the invention in the digital world, but has to be read in a more progressive, broader way. And as I go through those subtleties, it was very interesting to see how that definition, which started probably as a concept which I touched upon earlier called as a technical effect, later slowly the court moved the needle, what we now know as technical advancements, and this was the first time in this court where this needle was moved a bit further and they termed it as technical contributions, right, which kind of also touched the inventions which made certain advancements even if they touch the virtual world and they don't have a physical effect to it. Now, seeing the law moved on 3K on these three parameters, I'm left with no doubt, yes, courts are cognizant of what is going on. They are slowly moving the needle as things are coming to them. And there is a progressiveness in many courts on issues of IP.
Thank you. So let's talk about risk. So in my experience as a practicing attorney, I've noticed that most transfer of trade secrets or confidential information is usually unintentional or accidental. So we have employees who go home and talk about their day to their family, to their friends. We have marketing and the sales team at conferences or in the pursuit of getting clients revealing confidential information. So let's talk about what kinds of talk about these risks in the service industry and what we could do to prevent them or mitigate it. Anyone?
I think the most fundamental thing, and you mentioned it also, is the lack of, or you mentioned trade secret, and this was discussed before also, is the lack of protection under statutory trade secret law. You run into these issues, they become sort of breach of contract cases that take their own cycle. They're not considered as a part of IP, and we discussed this during our discussions in the speaker room, that how do you deal with such situations when you don't have a trade secret law and you have these trade secret theft, unintentional or intentional issues coming in, and you don't have the enforcement infrastructure to help you manage those situations?
Since we are talking about trade secrets and data theft here, I mean, just to give some focus on that. Thankfully, after the 2008 amendments for the Information Technology Act, you do have a provision which provides specifically against theft of data. So now it's broad enough to cover IP also. So the only issue there is that you have also a provision 81, which is the overriding effect of the IT Act over general laws, which puts in an exception for IP, saying, however, this does not limit initiation of prosecutions under IP. So the issue that arises when you are dealing with IP violations are that, there is a lot of confusion in people's mind on whether 43B as a civil prosecution or 43B read with 66 of the IT Act as a criminal prosecution can be initiated given the exemption in 81. So the exemption actually is very clear. That which is covered in copyright, trademark, etc., you may do that separately, and IT Act does not prohibit those kind of proceedings. But for data theft, including of IP assets in the form of, in electronic form, you can take the benefit of these two provisions. it doesn't stop you from doing that. So I was actually going to also, that's just on the data theft part, I was going to broaden the risk issue much wider to also say that even initiation of litigations are technically a risk. Because we talked about the Delhi High Court judgment on 3K, and I wanted to take Pankaj's one word there. He talked about consistency. And I wanted to just highlight that the difficulty that we are having in terms of convincing global audience of the robustness of India's IP laws and enforcement because of the latter, and because of absence of consistency in the latter. So we need to have systems which are going to be effective and functional always, which will ensure consistency and certainty. It cannot lend itself to forum shopping, which of course the Delhi High Court has now come down very strongly on. But who wouldn't want to come to Delhi, where laws are being enforced much faster, much better than any other jurisdiction, right? So why blame the litigant when the system is at fault? So I wanted to say that one thing, if you give me the opportunity to highlight as a risk factor, I would say it's litigation more than anything else. And again, the same weak link permeates everything, which is the human element.
If I can just add on the risk, as an organization, how do you de-risk, or what are your measures to risk mitigate, right? And you learn from your experiences. You know, risk comes into picture most of the times when you have third parties working for you. And to run a big organization, you do have a lot of third parties, and specifically a lot of tech providers who manage your critical services, which affect the experience of your end clients, right? As a rule, we ensure that any agreement that's happening with a third party, there is a well-buttoned, watertight IP clause that we consciously take a look at every 3 months, right? Every agreement, though it delays the process of executing agreements, but we are okay with that. But we ensure that there is a sign-off from our IP councils before a contract is executed, ensuring that the IP clause in view of the services and products provided takes care of confidentiality, indemnification in case of any litigation, right? And you know, it's, say for example, if there is a platform on which we've allowed a tech vendor to work on, where does the IP lie? Who is the owner of the IP? A lot of times negotiations keep happening with the likes of TCS, Infosys, Cognizant, Capgemini, where, okay, when it comes to something novel, who would be the end owner? Will it be someone like an Ameriprise or someone like a Capgemini or other tech vendors, is where a lot of time goes into negotiations. So these are our approaches to ensure things are on paper, they are well executed, you know, agreed upon by all parties before we even take any collaborations further within the business. So that's our thought on
I would like to just add to this, and this is slightly different than what my colleagues have said. My experience and thoughts on the trade secret is something which is not a very evolved practice by the IP practitioners. There are a lot of missing dots here. For example, what he said, that this is one area that he considered as a risky when you deal with the third party. The more riskier area is your own employees, and I'll come to that. But first I'll address that what normally is done to avoid or to mitigate the risk is to have NDA, non-disclosure agreement. Now see the limitation of NDA. NDA is signed between the two. If something by vendor's employee gets leaked and he is able to prove, or you are not able to prove that he has leaked it, that NDA has no teeth. And therefore, there has to be innovation in contract drafting. We have been doing it. That how do we protect if it is leaked by the what is called as employee, or by design the vendor itself leaked to the third party without keeping trace of it. how do you protect such kind of leakage is one challenge, and that is an area where IP practitioners can really get into. The second area is employee. A typical example I have encountered with when you have a team of product designs. You know, nowadays, particularly in consumer industry, particularly when it comes to the car, the value of the design is much, much more than the value of the patents. The design is not registered until the last date when they know that it will be announced and it is ready for launching. I know one of the multinationals, they have given right only to one person to see that design before it is registered. It is sent to us one day before. Not me, not his immediate supervisor can see this, only that I can have this one. That is the value of that design protection until then. Now the people working in those design teams, if they leave and join the competitor, and he carries that, and particularly nowhere, you can only protect what is information in the tangible form. And when I say information in the tangible form, legally, if I am wrong, please correct. If it is not in tangible form and if it is in the knowledge form, so I differentiate between the information and knowledge. It's one level higher than the information purely. The knowledge, if I carry to another organization, it's not protected. Contract law, probably section 27, does not bar me from using that knowledge. How do I protect such leakage to the competitor? That's an area which is not yet addressed. We have tried to do things here and there, but it is not yet perfected. I think this is an area for the IP professionals to work with the government and to frame certain legal framework or to innovate within the given premises there. Thank you.
Thank you. I just want to add one point to that. From my experience, if companies control the narrative, you develop the technology, you tell the story, keep it transparent. If you don't deny if there are any problems. If the story is yours and you own the technology in media, in publications, you tell the story. So I believe this helps because then no third party can claim that that was theirs because you've been talking about it right from the start. Blockchain, emerging technology like blockchain can help with this transparent process. Just my ideas there. Okay, so moving on, we don't have much time, so we're just going to do one last question. There's been a lot of disruption in innovation in the last decade. We've had Netflix, we've had Uber, we've had Airbnb. So any thoughts on what you think will be the new disruption in technologies in the new decade?
I think I will not specifically speak about the destruction, but I will say the potential, large potential. There are two potentials I see, and this is also a very greenfield area for Indian minds. Two areas I find that when all the technologies are available, it's more of integrations. So the people who are able to integrate these technologies to provide personalized services or personalized products is one area, because when it comes to integration, integration is nothing but innovation on interfaces. And one of the successful story and strategy of one company, Gillette, they worked purely on protecting, patenting interfaces. You take Mac 3, Mac 2, go backward to my younger days. We have seen the latching mechanism between the two parts, razor and the blade, has been unique. And they have been thriving on that interface design and interface innovations. Integration is all about interfaces. And these interfaces is something which is a green field for innovation. And when I say green field for integration, that means today we have plenty of sensors, plenty of actuators, plenty of connectivity, cloud computing is there. So things are in place. But how to dovetail this for the mass customizations, personalized services is something where you can do the interfaces. And most of these interfaces are likely to be in the area of algorithms. Algorithms is nothing but step-by-step process, because today it's not a age of hardware, it is an age of software. So enabling part is not by mechanical hardware. Enabling part, the interfaces will be algorithms. Now you will say that algorithms under 3K are not patentable, and that is where I said in the beginning that the art is in drafting. You need not be greedy to draft something what has happened in pure predictive versus H20 case. Pure predictive, it is an additive printing. Today all the manufacturing, barring some of the examples that we have seen in case of transplant, mechanisms, all are subtractive printing, all the machines. So these greenfield projects will give you the birth to the new machinery. It will not be by algorithms, but these are new machinery, new processes. How you are going to put layer by layer, how the bonding will happen, the speed of layering, all these are the areas of technology development. And this is where the Indians can play a part. The third area is platform, where India is not playing a part, where interoperability is an issue. That is why Germany is working on Industry 4 platforms. So it is a standards which will have interoperability, where Internet of Things will work, collaborate together. There I think we as an Indian do not have much space, because we are far behind it. As an individual we can do certain things, but as an organizations we may not be able to do things. There is a third area, but I will speak at last, and that is not in the area of patenting, but in the organization spheres. So I will request others to speak on this subject.
I just wanted to add, because it was mentioned earlier that we are all practitioners, legal practitioners here, I wanted to just mention that when we talked about disruption, it's automatically become tagged with technology, because disruption became a catchphrase thanks to technology. But I want to take that narrative further to, since we are talking services industry also here, of disrupting legal services. I think what we really need today is for lawyers, for practitioners or in-house counsel to think differently, disrupt the processes the way they have become used to it, and start becoming more innovative in the manner in which they are approaching their practice. For example, in my time when we first started as lawyers, and we were all litigation lawyers predominantly then, right? We were looked at as, we were looked at with fear. We were looked at as obstacles. We were looked at as the last resort, which you would ideally want to avoid. So lawyers per se became tagged as the people who you would not want to be associated with. Today things have changed. Lawyers have become and should become further, they should play the roles of enablers. We should be enablers who are going to help facilitate changes in the processes, help facilitate speeding up, help facilitate certainty in the enforcement of laws. I think that's a disruption that all of us would be looking forward to, and we are going to need it also. Because what is it that the disruption in technology has created? It may have taken away jobs. Today, one of the recent stories is that law clerks are being replaced by AI technology in the US. So if your jobs are going to go, they are really going for non-skilled or rote, monotonous work. So what we need to do is scale up, skill up, and ensure that we are ready for the next level. That's a disruption I think I would love to look out for.
I think it's sort of already been said, but I'll sort of encapsulate it differently. I think India's potential in terms of the next level of disruption, I would lay my my bet on service. I think we're a services sort of economy, and our ability to improve on that using data, using computation, is far greater than any other country in the world. And I think that that's where India has the potential to create those disruptions. And we may not be the creators of the platforms, but we can make things, the services that run on the platforms, better than what is being done right now.
Kind of agree with you. I think the future growth will be driven by machine connected to machines, right? Not machine to people, right? I think that is important, but then machines to machines, the kind of productivity enhancements that we are talking about, or making them more intelligent, is what I think will drive a lot of future innovations that I kind of read, at least in the technology space. And then bringing together people, process, data, and things, right? And then bringing them together to kind of, in a meaningful way or a relevant way, which not only provides information, but it converts into actions, right? A machine, and that is where the kind of assistance, I think, the technology. So I see a lot of hope in the machine learning aspects of it, and also the artificial intelligence. That is where I think the future innovations will be fueled in. Thank you.
Thank you. Thank you.
Just 1 minute. On our panel, Pankaj is providing the services of IP strategy. I think it is in that area also we can create some disruption and some thoughts. Particularly, I have seen that the management, the way the organizations are organized, how they organize their work, can be put it in different word. Aristocracy. Aristocracy means the position driven, that who is vice president, who is president. Then it changed to meritocracy based on who is expert and how you add value. The third is now advocacy, which is basically action driven. We want the actions to be done. I think the next era, particularly when the AI is taking over, the organization should be emocracy, emotion driven. It should not be mathematical decision making. It should be intuitive decisions making, and particularly the decisions which will be combination of certain part of fuzzy logic, not perfect logic, and emotions, and satisfy the emotions of the customers and use the technology for that. That should be one strategy that particularly IP practitioners can advocate to the industry. Thank you.
Thank you.